Okay, so a very hearty welcome to the Minerva Center of the Rule of Law Under Extreme Condition colloquium, and it's a pleasure to host today Professor Michael Birnhack, Associate Dean for Research and a Professor of Law at the Law Faculty of the University of Tel Aviv, also the head of the Institute for Intellectual Property in memory of Amnon Goldenberg. And Michael is a good friend of us because he started his academic career here at the University of Haifa in our faculty. And he will talk about a very timely topic, privacy under crisis, under the COVID-19. Michael, the floor is yours.
So thank you so much, Eli, and everybody at your center. It's a pleasure to be here and join you and discuss this topic. This is an ongoing issue in Israel and in many other countries, and we are at the midst of all sorts of events, some of which I will discuss later on, all related to the privacy aspect of fighting or answering the current pandemic. So let us begin. I'm sharing my screen. Is this okay? Is it shared? Yes, it is. And that's me over there. So I think we can begin. My discussion is partially funded by Ministry of Technology and Science grant, so I have acknowledged them as should be done in such occasions. Okay, so how do we deal with the pandemic without turning it into a surveillance nightmare? It might be a bit too late for that, but this is the current situation, and this is the tension that we are facing. As we know, when our lives have turned digital, as they are, whatever we do, from the very moment we open our eyes in the morning till we go to sleep, and probably during our sleep as well, we create digital data. We create that as part of moving, as part of using various technologies, the device mistakenly called a smartphone, which should be called a personal surveillance device instead, etc., etc. Once this data is created, there are many who are interested in collecting and using that data. Specifically, location data is the most important kind of data, but not the only one in the context of COVID-19. So privacy and epidemics, a general overview, and then we will narrow down into the legal aspects of this issue. We are all familiar with the way that COVID-19 develops. It's highly contagious, and the whole idea, as presented here in the New York Times nice illustration, is that if, or the sooner we are able to cut off one, contact, we may save many, many people from being, from suffering the disease, and obviously some of them may die. So the idea is to trace the contacts of an infected person as soon as possible and inform them about the situation, that they need to be self-isolated, etc., etc. In this regard, the contact tracing is one link in the chain, and it's important to remember that. Unfortunately, it seems that in some places in Israel, at the beginning of the pandemic at least, there was an overemphasis on this link and sort of neglecting the other links. All the links are important in this regard. The more tests we have, the better. The faster the tests are, the better. And then we have to identify the contacts in order to send people to isolation and more tests, etc. In this regard. How do we identify contacts? The contacts, the people who came in touch in a way that, according to the specialists, the experts in the field, is dangerous enough, and there's a risk that they may have suffered the same disease as well, that they have been infected. Well, one way is asking the people. These are the epidemiological inquiries, And another way is technology. And of course, some of these or both channels can be combined. In identifying the contacts, in tracing the contacts, there are some informational needs and challenges. First, the infected person has to reconstruct his or her path in the past 14 days. And in many cases, well, people don't remember. Think of it. Each of you for your own, where have you been 5 days ago at, I don't know what, 8 p.m.? You know, some of us may remember and we may, you know, ask or sort of figure out, but many of us, we have no idea where exactly we were unless there's a complete lockdown and we know that we were at home. Then we have to identify the people that we have met. So we might know about family or friends or colleagues, but you know, if I took the bus or the train, there's a person there, I have no idea who he or she are. So it's difficult to identify the strangers. So we have an interest in tracing the contacts in as fast as possible, as fast as we can, and we would like it to be accurate. As we have seen in the Israeli experience, there have been numerous mistakes of different kinds. There are false positives and false negatives. In one situation, we identify people as contacts even though they were not. That has unfortunate and expensive implications because these people are sent to isolation with no reason whatsoever. Today, people can call and appeal and say, hey, this is a mistake, I wasn't here, I was there, etc. And then they are released. And this is the language used over here from the duty to be isolated. But others who are not quite sure, do not know that they can appeal, etc., they spend some time in isolation at home without going to work, if that's allowed, and not seeing other people, etc. So that's an unfortunate result. The other kind of mistake is that we miss people that should have been identified as contacts, and they may have been infected. They do not know that, and they may further spread the disease to other people, the virus to other people. Then we have another challenge, and that is that many people do not have smartphones. So in Israel, many people do have phones, mobile phones, but not all of them are smartphones. And for those people who do have phones or smartphones, not everybody carries them all the time. For example, Jewish religious people do not carry smartphones or any other kind of phone on Saturday during the Shabbat. And then, even after we have found the people, we have to inform the contacts. That's another challenge, how to do that in as fast a manner as possible. But the informational needs do not stand alone. We also have social and legal needs. First and foremost, public trust. Public trust is something in Israel and in many other countries is lost. It's lost in the government for a whole host of reasons, but during the pandemic, I think this is the number one overarching failure of the government in handling this pandemic. People simply do not trust the government, and we see that every day in, whether people wear the masks or not, whether people obey the instructions or not, and also in our context of contact tracing. Social solidarity. Social solidarity is important. Solidarity means doing something which is uncomfortable to us, maybe even costly in some way, but nevertheless, we do that not for our own sake, but for someone else's sake. For example, the masks. I may be absolutely sure that I'm okay, that I'm not sick, etc., but nevertheless, I will wear the mask to indicate to others, even if they are far away, so I'm not a danger. Even when I'm alone in the park, I will wear the mask to signal solidarity. And I think trust and solidarity are crucial in handling pandemics. If we are to obey the instructions the government orders of staying at home and not meeting people and et cetera, we have to trust the people who tell us what to do. And we have to do that because of solidarity and because we understand that, especially in a pandemic which is contagious, my health depends on your health and vice versa in a network sort of way. And then there's privacy. So I will delve into privacy shortly, but it feeds back into the trust and into the solidarity issues. If we enjoy privacy and yet the functions for dealing with the pandemic are met, then our trust in the government will increase. The less trust in the government we have, the less privacy we have, it all feeds into each other. For this, we should or need to develop a system that is usable, that achieves the goals of the functional goals, that is effective and feasible, and maintains in as much as we can trust, solidarity, and privacy. And then there's some technical issues which are important to make sure that the battery of the cell phone, the smartphone, does not run out very quickly, because then people will not use it. That it's interoperable across platforms, whether you are an Apple user or an Android user, when we travel to other countries, et cetera, et cetera. Very technical, but crucial issues in this regard. So we have the informational needs, and we have also the social and legal needs. And then we have the crisis, and we see different countries dealing with this differently. And I'm speaking about the link in the chain of contact tracing. So we see some non-democratic countries, such as China, using its security services, as well as Israel. As far as we know, Israel is the only country, the only democratic country to use its own security service for/against its own citizens in this regard. Many other countries, Israel included, have developed various technologies for contact tracing technologies. There are various applications, governmental, some initiated by the governments, some initiated by public companies, etc. So let's move to the law and the concerns, or the privacy concerns, that we have here. And first, let's see what Israel has done with its bulk surveillance under or by the Shabak, the Shin Bet, the General Security Service, the Israel Security Service. It's all the same body. So the Ministry of Health transfers to the Security Service, to the Shin Bet, a list of people who have been diagnosed as positive to the virus. Okay, and the Shin Bet receives this information and traces the whereabouts in the past 14 days of people who have been in contact with the sick or positive, COVID positive people. And how do they do that? Well, it's a bit of a mystery, and that's part of the problem. We do not know exactly. Obviously, it is based on smartphones, but we do not know exactly which technology do they use. We do know about some limitations of this technology. And this is one of the reasons why the Shin Bet has objected to the use, but, succumbed and obeyed to the governmental instruction. Whoops. Am I still on? I hope so, because, guys, am I still on, or?
You are still on.
Okay, thanks, because something has changed here in the presentation. The Shin Bet did not like the job that it received. One of the reasons was that it reveals the shortcomings of its systems. For example, we have realized that the Shin Bet cannot know whether I'm on the second floor or the sixth floor of the building, and it's ineffective within places like shopping malls, etc. Anyway, the GSS, the Shin Bet, traces the whereabouts of the contact and provides the information back, feeds the information back to the Ministry of Health. How effective is it? Well, there are different numbers. The Ministry of Health at some point claimed that 30% of the infected cases were detected using the Shin Bet tool. According to the state controller's report from a couple of weeks ago, It's only 3.5% of the people. Now think about it. Many people realize that they are sick because they feel unwell and they go and have the test, and this is how they realize that yes, they have the COVID. Others expect that because someone in their immediate family or workplace, etc., has been diagnosed as carrying the virus, and so they kind of expect that this is the case. Meaning, in other words, that in many cases, people already know that they are sick before they get the phone call, which is based on the Shin Bet's tracing. The privacy debate, okay? So the Shin Bet and the Ministry of Health have argued that they have undertaken various measures to minimize the harm to privacy. So they say that only a very limited number of people, of staff, have access to the data. I think it's about 50 people, but who knows? They claim that it's confidential, but we have very little means to check that this is the case. They claim that they will not be using the data for anything else other than for contact tracing, but we have to believe them. And there's a time limitation. Currently, it's under a law which will lapse in a month or 6 weeks or so. But as I've repeatedly said or hinted along the way, there's lack of transparency. When the Shin Bet operates, it operates in the way that it knows how to do things in secret. It's not transparent. When things happen in an intransparent way, it's very difficult to review and check. And balances are a bit difficult under such situations.
So the security service is intransparent, and this means that it's very difficult to conduct any checks and balances. And basically, the government asks us to trust them. How, why, details, information, data, nothing. Trust us. This is what they say. Solidarity in such a situation is very difficult because we are expected to follow orders rather than do things out of our own will. And yes, there are concerns for short-term misuse and abuse. I'm frankly less concerned with that. It's a concern, but I'm less concerned with that. I'm far more concerned with the long term. What happens with the day after? If privacy, which is a fundamental human right, if it collapses when we need it mostly in times of crisis, then what happens in the next crisis, whatever it is, or in minor events, because the principle has already been broken. Yes, our privacy can be traded off in this way for a different cause. Whether this is justified or not, we shall discuss shortly. As you know, the initial governmental instructions and orders to use the Shin Bet for this purpose were challenged by the Supreme Court, which held a televised oral discussion in April, and it handed down a decision shortly thereafter, saying, well, authorization in a statute, well, okay. Kind of, the Shin Bet does have some sort of authority to do what it is doing. Privacy, the court acknowledged, was violated, but nevertheless, it said, well, the current scheme at the time was about to expire, and it will expire, the court ordered, unless the government initiates legislation. The court did give some points and said, well, legislation should be temporary, proportional. The court mentioned privacy by design, consent, data protection, etc., and also instructed to assess alternatives. Indeed, the government shortly has come up with a statute which has been it's valid until 6 more weeks, so it's temporary. Whether it's proportional or not is currently challenged in a new petition which is pending in the Supreme Court, and alternatives, I will discuss that shortly. The argumentation or explanations in the court's opinion are fascinating. Chief Justice Esther Chayut has framed the matter as one of vertical balancing. Now, for those unfamiliar with Israeli constitutional law, a short comment on that. The Israeli Supreme Court has developed over the years an entire balancing language. The language uses mathematical sort of metaphors of balancing and formulas, vertical, horizontal, weight, inverted weight, and all sorts of things like that. And the court often frames things or conflicts between rights and interests, public interests, as either vertical or horizontal balancing. So the vertical balancing suits a situation where we have a fundamental human right, such as privacy, when it is in conflict with a public interest, such as public order or national security, etc. This fits a vertical balancing and is handled under Article 8 of the Basic Law, the Limitation Clause. When the court identifies two equal rights or a right or two equal interests which are on a par, then the court applies a horizontal balancing, and the instruction is to sort of try and have both. So the vertical balancing often results in either or, and the horizontal balancing typically results in let's try and make the best we can with both rights in as much as we can. So Chief Justice Chayut framed the situation as one of vertical balancing of privacy vis-a-vis or against public health, portrayed as a public interest. Justices Meltzer and Solberg defined the same situation as a horizontal conflict between privacy and life. So here's a quote from Justice Solberg. There's more work to be done to protect and ensure privacy and intimacy, and we must do it, but not necessarily in the given crisis that pits the rights of privacy against the right to life and health of people and of the entire public, a life-threatening danger in the plain sense, and a real fear for Israel's economy. So it's privacy against the right to life. In this, the justice has privatized or separated the interests of the public to public health into each of us, each of the individuals' rights to health. This is exactly the kind of manipulation that the entire balancing language enables under Israeli law, which is something that I've written about ages ago, and others such as Amnon Reichman and Oren Gazal have written about, and the courts are quite aware of what they are doing in this regard. So I've just discussed what we have on this slide. The initial classification of the rights and interests at stakes matters, because if we understand public health to be an interest, we go to a vertical formula of balancing, which makes it more difficult to infringe the right to privacy. If, however, we place privacy and life on one against each other, the result is obvious, pro-life in this sense, and privacy loses entirely in this situation. Okay. However, there are alternatives. How do we reach the alternatives? Within a vertical balancing formula, there's the issue of proportionality. The measure undertaken should be the least intrusive means. And indeed, Justice Chayut has mentioned the idea of privacy by design by reference to scholarship about the topic, and developing an alternative, a civil alternative. Civil in the sense that it's non-military, non-Shin Bet kind of technology. I will go back to the privacy by design issue in a short while. What happened after the case, just so that we're on the same page? As I've mentioned earlier, the court has, the Knesset has legislated a temporary law, which is currently under review in the Supreme Court, but it's more or less what it has done from the beginning. However, following a civil society proposal, disclosure, I was part of that initiative, a section was added, 12A, which requires the Ministry of Health to develop and apply and deploy a civil solution rather than the Shin Bet. Criticism has mounted since all of this has started in March. The state comptroller, as I've mentioned, said that it's hardly effective. The privacy agency, the Data Protection Agency, which is a unit within the Ministry of Justice, has repeatedly objected to the continuation of the Shin Bet surveillance, and has most recently suggested that it is limited only to situations where a person refuses to cooperate during the epidemiological inquiry. All of this, taking a broader view, is part of a bigger question. The technological solution can work only if it is part of an overall management of the pandemic. It can work only if society responds, cooperates, trusts the government and other clerks and leaders who tell us what to do, and only if the law fits all of this. There's no magic solution here, and all the factors here, and there are probably more, and each of them contains, of course, a lot more than just a headline. Everything sort of interacts with each other. But what is missing, and now I'm zooming in on the privacy discourse, is an articulation of the privacy harms. The Supreme Court has assumed that privacy is harmed, and that it is, of course, the case. But I think the court should have done more work in articulating what exactly is the harm to privacy. Otherwise, it's very difficult to assess whether one solution is proportional to the goal. If we do not understand what exactly is the harm, how can we suggest other means to address that harm? Obviously, it's data about location. Data about location reveals a lot of intimate things about us. It reveals whether we have gone to a clinic and which kind, whether it's a cosmetics kind of clinic or an abortion clinic, whether we have been to psychological therapy or psychiatric therapy, etc. Location may reveal whether a Jewish religious person, well, does not exactly obey the rules of the Shabbat of Saturday and has traveled from one place to the other. Location may reveal sexual preferences and sexual activity, etc., etc. It may also reveal the data is about health, whether we are sick or not. Now, of course, this is the entire purpose, right? We are interested in figuring out who has been in close proximity to a person who has been diagnosed as carrying the virus or even sick. But it may reveal other kinds of health data. The tracing also reveals, by proxy, our relationship, our social contacts. So it's not necessarily the case. It might indicate that I was sitting on the bus next to a person who's a complete stranger, but then I will have to explain. For example, if it turns out that that person is a drug dealer, I may be associated with that person. Relationships which we are less interested in revealing may be revealed in this matter. The focus of the government, the Knesset, and as far as I can figure out, the Supreme Court was on location data. They have neglected to identify the other kinds of data that may be revealed by using various contact tracing technologies or the Shin Bet. So let's talk about contact tracing technologies which are not by the government. I will not go into great detail, technological detail here. I see we have some experts such as Or Dunkelman and others in the discussion, so they are invited to explain more as they wish during the discussion. The contact tracing is part of what we call privacy by design. Privacy by design is an idea which has been circulating in privacy circles for more than 20 years now, and has been successfully promoted by Dr. Anne Kevokian, the former Information and Privacy Commissioner of Ontario, Canada. The idea is very simple and very intuitive, at least to lawyers, less so to engineers, and that is embed privacy into the design of the technology ex ante, at the beginning, when you design the technology, rather than ex post, when it's too difficult, too late, and too expensive to do. Contact tracing technologies can be centralized, meaning that there is some central point where all the data goes through. If this is the government, obviously it raises obvious privacy concerns. It can be decentralized, meaning that the system can still function without a centralized focal point. HaMagen, the shield, the Israeli contact tracing developed by the Ministry of Health in the first version. I got a phone call in early March from the Ministry of Health, from the technical department, not from the legal department, saying, we are busy developing an app. Can you help us with the privacy aspects? And they told me a bit about what they were doing. I said, my response was, oh, wonderful, you're doing privacy by design. To which they responded, what are we doing? So they were doing privacy by design without knowing that this is what they were doing. So the app was voluntary. You were not under any obligation to install it. It was based on location, and it was semi-centralized. It's the only centralized part was the push, the information from the Ministry of Health about the whereabouts of the sick people. But this data was pushed to users' applications, their phones, in an anonymous and encrypted way. So if I have installed the application, which I have at the time, I received the data came in, but without me knowing that the data comes in this regard. So the data came in about the whereabouts of sick people, but the match was done only on my phone. All the data was kept only on my cellular phone. Nothing went out. Importantly, users were able to uninstall the application and delete everything from their application. In other words, data subjects were in full control of the data. Importantly, the code of this application was published on GitHub as an open source so that it can be reviewed. All of this is exactly in opposite to the Shin Bet. It was transparent, it enabled control of the users, and only the users, no central government, full transparency of what is going on. There were other kinds of applications, for example, Trace Together by Singapore, which has some other elements over there. It was based not on locations, but on proximity. HaMagen 2, the second version, was based on both location and proximity, and I did not advise them on that. They were on their own on this, and today all Israelis know that this has failed. It has failed because the technology apparently was not good enough, and it was not promoted in a good enough way. Mostly, I think it failed because of the issue of public trust. Why on earth should I download an application and trust the government to say that it's doing what it's doing, when at the same time the government continues its bulk surveillance after everybody? There simply doesn't make any sense in doing so while we know that the government continues to do or undertake bulk surveillance. What does all this mean? And with this, I will conclude and open up for a question. Design matters. Design matters because design can embed privacy in the technology. and surveillance and public trust and solidarity are in opposite here. And this is a choice that the government should have made. It has. The government has chosen, the Israeli government at least, has chosen surveillance. It could have done otherwise. And I can only regret that it continues to use surveillance without trusting the public, without sufficient transparency. We do have additional new challenges. The other day, there was yet another discussion in the Knesset committee that looks into this matter, and they came up with a new idea. Maybe instead of the Shin Bet, we should opt for forcing people to use an app which is supposedly civil, such as HaMagen 3 or whatever it will be, or something else. I think it is a terrible idea. Okay, first, it means that now we know that we are under surveillance. We are at no liberty to choose otherwise. We will be forced to use such an application wherever we go. We will have to use it in order to enter shops, etc. What about people who do not carry a smartphone? What about if I forgot to carry my smartphone? What about someone going to synagogue on Saturday? Will they have to carry that? Obviously, that raises issues of freedom of religion, etc. Much of what I've discussed appears in some papers in Hebrew, one of them in Law and Government, Haifa review, that's in Hebrew, as well as a report that I've written, co-authored with Miki Zar. It's also in Hebrew. Privacy by Design, pre-COVID-19, in a paper with Toch and Hadar, explaining why it's a great idea, but it has some of its challenges, and other papers along this way. Avner Levin has written an important paper about the better chances of privacy by design in the governmental sector, the public sector, which is exactly what we are discussing here. So thank you for your attention, and let's have some discussions now. I do not know if you're on my cell phone or which other application, but I'm questions, please.
Yes, thanks, Michael. It was fascinating, well presented. I have on my list Rafi, Gadi, Amnon, and Shmuel. So Rafi, the floor is yours, please.
Michael, first of all, thank you very much for this tour de jour of presentation. You certainly provided a lot of food for thinking. I have many questions, but with the chair permission, I'll restrict myself to three, if I may, Eli. The first, if I may, if you can define contact, please. What makes one contact? Are there any consideration that relating, for instance, to time? If I've been on a bus for, say, 10 minutes, should I explore the bus, or it's not sufficient enough? If I'm in the vicinity of someone for 5 minutes, is he or she a contact? Does it matter whether he or she and I wearing a mask or wearing gloves? Are there any criteria for contact? That's the first question. Second is, of course, there's a vast difference when you employ HaMagen or any other app voluntarily, or if you enforce this not voluntarily. And of course, there's going to be a huge difference between the two. At least in Britain, we've seen that here there's an app, and I don't recall the recent numbers, but they're very low. I mean, less than 1 million, I think, maybe tens of thousands, in a population of 64 million. So should we insist on voluntariness when we know that a significant part of the population is not going to install the app? And then, of course, the usefulness of the app is going to be very, very low. And the third question is, and that's something that I did not hear of any discussion until now. Instead of speaking of society, should we speak of certain population, certain segments of the population that are more susceptible to harm as a result of COVID? I mean, again, in Britain, there are hundreds of thousands, well, I don't know how many, at least 150,000 students in universities. We know that dozens of thousands of them were affected by COVID, And until now, the number of deaths is 0. So should we really be interested in students as such, or should be interested in their contacts when they come into contact, say, with elderly people or with people who have asthma or obesity or any other criteria that made them more susceptible? And therefore, when we speak of segments of the population, maybe the implementation is going to be easier, and also it's going to be more transparent and clear to the population why I'm not allowed to go to a shop, why I'm not allowed to go with my dog outside 500 meters and so on, when I'm not encounter anybody. I think that would make more reason. I wonder what you think about all this.
Okay. Thank you so much. So I will try and be as brief as I can to enable discussion. Contact, the definition should come from the experts in the Ministry of Health and other experts. So currently, their view is that a contact of more than 15 minutes in a proximity of less than 2 meters, that's the definition. Okay, so the technology should be designed accordingly. It should be designed to trace people who have been in 2 meters or less distance for more than 15 minutes. Okay, so and if they change the definition and they are the experts on what are the chances of someone being infected. Am I still on?
Yes, you are.
Yes. Okay. So something has changed here. So they will give the.
Now we are not on. Michael. Michael?
On proximity. How it is done? It is done by an exchange of Bluetooth signals between devices. Okay, this is how it is being done. About the voluntary and forced issue. Once again, contact tracing is only one link, one tool in a vast toolbox. It's one link in the chain, it's one tool, and it's only one tool. And it's not a magical solution. Unfortunately, what we see in Israel is that the Ministry of Health and the Prime Minister and the government and the Knesset have fallen in love with the technology. They simply fell in love. And that has been, I think, a huge mistake. Because once they fell in love with technology, they have neglected other tools in the toolbox. They should have had more tests at an earlier step, encourage people to do so, develop alternatives earlier and forcefully, etc. They have not done so. They have fallen in love with the technology. And for example, in Israel, what we see in recent weeks is that finally there is a well-functioning, although military run, but a well-functioning system for personal, human, and humane inquiries, epidemiological inquiries. They are effective. So yes, there are people who do not cooperate, and yes, there are people who lie, etc. But the guys who are doing that, I have a few students who have volunteered and are in that operation. They have learned how to ask and how to question people, and their epidemiological inquiries are effective. Now, the more we spend and emphasize a technological solution, we neglect the other options, and that is wrong. And I think that the human and humane interaction, when someone asks me, where have you been? Are you sure? What about this? What about that? Oh, I'm so sorry about what happened, etc. I think it has extra value in the interaction between the government and citizens, and a way to enhance and develop trust. Now, as for your third question, that goes way beyond my expertise as a privacy scholar. So I will sort of leave it open, but there are challenges there, right? So we want to target the weakest link in the chain, meaning the people that are most likely either to spread or to suffer the most severe consequences of being infected, right? So that's who we would like to to target first, but we have to be very careful with stigmatizing some societies. And I think the data, and once again, this is not my expertise, but the data is that in the United States, and I think in Israel too, the lower your socioeconomic status, the more likely you are to have suffered from COVID. Okay? I think there's some data about that. We have to treat different segments in the society in a way which is respectful and does not stigmatize them. I think the Israeli government has failed with that as well. Eli, you are muted. Eli, you are muted.
Okay, so Eli, okay, so thanks very much, Michael. I think it's a very convincing argument and very sound. And I would like just to ask kind of three questions or comments. One is about privacy and public trust. So I would think that the government would impinge upon privacy or infringe privacy during the pandemic in any case, regardless of public trust. Don't forget, by the way, that Israel does have practices of surveillance and impingement on privacy, partly because of the military occupation. So Israel knows how to do that. And so I was not very convinced, if you can at least elaborate more, the causality which in a way you suggest between privacy and solidarity. Let alone, I would in effect prefer lack of solidarity as a way to fight against infringement of privacy. And incidentally, you would have much more probability of judicial intervention, because justicability obviously there is, but the question of judicial intervention, the probability is much larger once you don't have solidarity regarding the government. So this is one question, if you can clarify more the causality between privacy and solidarity. The second question, I think that there are two constitutional arguments which you are raising in your lecture. Firstly, you know, the fundamental right of privacy, which is embedded in meta-legalistic and legalistic arguments. But the other argument is regarding the Shabak, that if you read the law of the Shabak from 2002, especially stipulation clause number 7, I would argue ultra-virus. I mean, the Shabak does not have actually an authority to surveil for purposes of recovering from the pandemic. And the third question is about engineering privacy. If you can talk more, please, about how to regulate it. Are we supposed to regulate the engineering technologies of privacy? Thanks, Martin.
So thank you so much, Gadi. These are excellent questions. I will begin with the second and third and then go back to the first because that's the most difficult one in this. You know what? I will be in order. Privacy and solidarity. Think of the following situation. A COVID positive person, as we know, may be infectious even before he or she knows that they are positive. Okay? And they wander around and they meet family and friends, etc. Now they realize that they have been diagnosed. So obviously it's a bit of a shock and they are concerned and they feel unwell in many cases, etc. And, you know, in some cases they need a medical treatment, etc. Another concern they have is, oh my God, I may have infected some of my closest, you know, the people closest to me, my family, my grandparents, my colleagues, my friends, my neighbors. That's an unfortunate, I wouldn't like to be there, because if I knew that I infected someone who died, that's a terrible feeling. And this, I think, is where it's important to nurture solidarity, so that each of us understands that when I wear a mask, it's to protect me, but also to protect others, so that nobody is sick, whether I like them or not, whether, etc. So I think in this regard, solidarity is crucial, okay? And especially when the government, and it ties into the public trust, and these concepts, they do have a very complex relationship: trust, solidarity, privacy, or lack of privacy, which I'm trying to unpack. And your question is right on point in this regard. So I do think when we act, not because we are told, but because we understand what is going on, because we care about thy people, because we care about our brothers and sisters and family, etc. That's important. That is when we internalize the importance of obeying the rule. We obey not because we are afraid. It's not a command sort of system. We obey because we truly understand the risks to ourselves and to the people who are most dear to us. This is the point of solidarity. When the government says, privacy, forget about it, we have a better tool, okay, bulk surveillance, etc. This signals lack of trust. That signals we don't trust you, the people, to care about yourselves and about each other. We will take care of that, okay? So why should I bother about solidarity if it's the government's responsibility? The government will figure out who are the people that I may have been in touch with when I am asymptomatic or even later on, and the government will take care of that. And I think that diminishes the agency that I would like us to have, each of us to have, in a liberal democracy, where we act not only because we are afraid of being punished, but because we understand the negative consequences and we care about each other. We understand, or should understand, that, we are all in the same boat. It's part of a network, and all these metaphors which reflect the close relationship between many, many people. So there's much more work, analytical work, to be done about these concepts, but this is where how I think about these matters. Yes, I completely agree with your second point, that reading the Shin Bet law, there is no statutory anchor there for what the Shin Bet is doing. It's a national security law, and it deals with national security. And the Shin Bet traditionally has thought of itself as a national security body and nothing else. However, when the pandemic broke out and everybody was nervous, including the government, and rightfully so, this is what they were doing. And I think everybody knew that there was no statutory anchor there. But the court said, well, maybe extreme circumstances, whatever. I think this is regretful because it's part of what I have called repeatedly since the beginning of the pandemic, the securitization of this pandemic. This pandemic is a civil crisis. It's a major civil crisis, something we have never faced before. None of us, okay? None of us living today. Humanity has, but none of us living today. We have never faced any civil crisis of this kind. Civil crisis should be handled with civil tools, not with security.
Michael, we lost you.
Michael?
Is, for example, lack of transparency. Their mindset is that we govern and rule rather than cooperate with people. Okay? And I think that has negative consequences at present for handling the pandemic. And my concern is what happens also the day after. Privacy by design, how to regulate. Well, in the EU, under the GDPR, privacy by design is a duty. whoever collects data is under a duty to conduct a privacy by design process. The GDPR says nothing about that. It says nothing about how to do that. There's the duty, but no details, which makes sense because one size does not fit all. It's one thing, I'm a major insurance company, just an example, and I have to undertake some privacy by design measures. It's another thing if I am the government or some agency, and it's yet another thing if I'm, the cafeteria, which has some personal data about its 2 employees. So one size does not fit all, and there's a large leeway for creativity for the engineers in this regard. So it can be a legal duty. It's not yet in Israeli law. However, there's one very important decision by the Tel Aviv District Court by Judge Michal Agmon-Gonen in a different context, where privacy was at stake and location data, etc. And there was an application developed or ordered by the Ministry of Defense, different context. And the judge said, well, clearly you have not even thought about privacy, let alone embedded it into the technology, go back to the table and come back with a better solution. In other words, it can become a duty under administrative law, or I would say constitutional law, as a more proportional measure to address whatever needs there are.
Okay, thanks.
Thank you.
Thank you, Michael. Amnon.
Hi, Michael. How you doing? So I want to begin by totally agreeing with your premise and the structure of the argument. More specifically, I think that the court, Meltzer and Solberg, made a mistake when they confused vertical and horizontal balancing, and it carries huge consequences with respect to that particular case and the rest of what you call constitutional engineering in Israel, because it has implications on the way we balance rights in general, and we should just call them upon it and just say, no, you just got it wrong. And I think you're right with respect to the legal analysis, with respect to the notion of the legal power of the General Security Service, who actually, as we all know, they actually don't want to do that, as you noted, for many reasons. They don't want to disclose the technology. They don't want to be sucked into this civil, and they know they can't extract themselves. It's difficult for them to extract themselves. And they don't want to create another department, the General Security Department for civil surveillance, etc. I do want to push you, however, on three and a half points. One is, as Gadi noted, on the relationship between trust, solidarity, and privacy. But rather than from the perspective of Gadi or the structure of the relationship that you're trying to unpack, and I'll touch upon this just in a second, on the empirics of it. Because in the Minerva Center, we've been wondering just about that, because trust matters not only with respect to privacy, right? Trust matters generally when, it's a key feature of what we call resilience, which is a clear indicator of an ability of a society to withstand and then recover any kind of an emergency, the notion of resilience. And the empirical data, to the extent we have some in Israel, suggests that actually we don't see any correlation between lack of trust and privacy. So I wish we did, because I totally share your sentiment, and I'm on record on that. There was a meeting in the center that Deborah Shmueli runs that deals with the government, and I insisted that we should put this notion of alternative to the GSS because of trust. But it's very difficult to advance this when the data that we have, and we do measure trust continuously, we measure trust, and there is no effect here. Part of the problem is to the extent that there is decrease in trust, and we do see some decreases in trust. They relate to the irrationality of the regulation altogether. So the government failed, and you noted this, that privacy is just one element of the bigger picture. Now moving to the second point, it gets swallowed by other mistakes the Israeli government is entered into. And here, I want to tie it back to privacy. So we know, because we've been studying emergencies for some time now, that there's a host of at least 6 modalities that the government can use when dealing with anything, including emergencies. And carrots are important, not only sticks. And what we see with the HaMagen, and there were no carrots offered for those who use it. And that's troubling. It relates in another forum that we had in the cyber forum, we talked about the relationship between the different Knesset committees. The one Knesset committee is not allowed, it doesn't have the power to offer carrots. The carrots committees are other committees, and there was a miscommunication within, a lack of communication within the Knesset. But just to make the point, here there's a clash between privacy and carrots. Why? Because if you insist solely on being voluntary, the question is what you mean by voluntary. If I give carrots and I say to some private institutions, you may open if you are sensitive to privacy because there is an app that does that, clearly I think it's a good idea. But then the notion of privacy is totally voluntary, yes or no, comes into question, and then the government can kick in and say, we're going to give you some tax incentives if you do that, we're going to give you other type of carrots. So the ecosystem wasn't calibrated in that respect. The notion of releasing, unlocking data, there is another project now by the government to unlock data, so there will be this ecosystem, raises interesting questions. And I want to conclude analytically by what you're trying to unpack. So what you say, solidarity, suggests that I care about others, right? And this is part of the rationale for obeying the law. But I think you should unpack that, because there is a version of solidarity, but there's also what I hear you say is actually agency and responsibility. And that's actually individualistic. I mean, I could care as an individual. So in the United States, they don't talk about solidarity so much. They talk about agency and individual responsibility, which is distinct from that. And then it is geared more towards the market, and let the market operate. And we don't want the government. We want to take care of ourselves, not necessarily for solidarity, because of self. We just want to. There's a self incentive here, which ties back to the technology, because the question is whether you regulate the technology bottom up or whether there's demand below for interoperability. We talked with, again, in Minerva and in others, that part of the problem that the technology is not necessarily mature enough because there's no market for it. So the idea is how to create a market for it, not necessarily top down, but also bottom up, is another challenge we've been working on. So to conclude, I think our projects are really consonant with each other. So we've been worrying about issues like that. Privacy is part of it, but maybe we should continue the dialogue about how to integrate it into the other modalities of regulation.
Oh, fantastic. So, I'm from, I come from privacy rather than from regulation, and that can be a fascinating project, and I'm open. Let's discuss. So let me try and answer. I'm not sure if I have full or good enough answers, but I will do my best. The empirical stuff. I have not conducted an empirical study in the Israeli context, but first, I do recall a Swedish study conducted before COVID on one of the previous SARS pandemics about masks, about the willingness of people to wear masks in public when asked rather than required to do so. And they did, in the Swedish context, of pre-COVID, but some other pandemic or epidemic, they did find a very strong correlation. Now, I'm pretty sure, I would love to hear more about your study, but I'm pretty sure that there are other studies ongoing, as we speak in the last few months, etc., about various things like that. Eran Toch and Doshat Ayalon had a study on that too, which the results I will It will be wrong for me to quote from my memory because I will do no justice to their study, but we can look it up. It's very difficult to measure. It's difficult to measure public trust. It's difficult to measure public trust under conditions where you do not have a control group, right? Because we are all under a situation where we are under state surveillance. In Israel, I'm speaking. So it's very difficult to say, what do you want? What do you don't want? Do you like it? Do you not like it? Etc. etc. Moreover, some other challenges for such a study. Not everybody knows. Not everybody knows that the Shabak is following us, tracing us, and exactly how they do that. Once again, lack of transparency. Another reason, another challenge here, and these are challenges that we see in empirical privacy studies across the board, okay? Resignation. People give up. People say, well, it's beyond me. I cannot handle this. And over the last year, people are handling a lot, right? Everybody's under stress. Many people have lost their jobs. Some people are sick, or if they're not sick, their families or friends or colleagues are sick and they are concerned. We have a lot on our minds, and it's difficult to sort of, take care of everything. One at a time sort of approach. And people sort of adapt a state of mind of resignation. Okay, I cannot handle with everything. Let it be whatever it is, even if I do not like it. Another problem with surveillance is that it is secret. Until we receive a notification from the Shin Bet, it's sort of vague, it's sort of general, but we do not realize that, wow, they're actually doing that. Okay, once we have received a notification, some of the audience, I'm pretty sure, it's a different thing. But up until this point, it's quite a vague, amorphic, elusive, very difficult to grasp. So these are some of the challenges of conducting an empirical study. Now, I'm not saying that such studies should not be conducted. They should, but they have these inherent challenges in the current situations that I would point to. There's a broader point here. Privacy is often led by few for the benefit of the many. It's a unique human right in the way it plays out in the real world. Freedom of expression is something that more people sort of know of and realize because of censorship, demonstrations, etc. Privacy is more difficult because of the inherent issues with privacy, that it's elusive, we do not realize it, etc. And traditionally, we have seen experts, lawyers, justices, NGOs, civil society sort of leading this. We have seen quite strong support for various civil society initiatives over the last 10 months or so. Okay, there's a new NGO devoted to privacy that was established, which has received quite substantial support, etc. So it may be paternalistic, the care for privacy, but I think it is justified, this paternalistic reason. Carrots. It would have been wonderful if the government could offer us some carrots, but then we run into digital divides and equality issues. If one of, I think, Chulon or Bat Yam, one of the cities south of Tel Aviv, has offered people financial incentive by way of participating in a draw for taking the COVID tests. Now, I'm not sure I like it. Okay, I feel uncomfortable with that. Now, the incentives or the carrots that you have mentioned were mostly for shop owners, right? For shopping malls, etc. If I understood you correctly.
So there's that. Sorry to cut you. There's that, but there's also incentives for individuals. So suppose you abide by and install this or that, you will be the first that we will visit and help you by giving you food or giving you medical attention, etc.
So, unlike the American Republican views that you have mentioned earlier, not your own, I'm sure, but you have just mentioned them. I'm it ties into the solidarity. I still do believe in the importance of solidarity for social cohesion and the community. Okay, so here's the schmutznik out of me, which I'm not a kibbutznik, but I have some in the family. How does it go? To everybody gives as much as they can and deserves or should deserve as much as they need. This is rough translation. I'm sure it's the original is in better English or Russian, but caring for the community doesn't necessarily mean one is a communist in this regard. So I'm for incentives, but they should be offered in a way that addresses everybody and does not prioritize those that are already on the haves side, rather the have-nots side. And the carrots, if they are directed to us, the data subjects, the individuals, it's one thing. If they are directed to shopping malls or service providers, I am way more concerned because they have other incentives as well. The shopping mall would love to have the full list of people who stepped in. Okay, that is data that is worth a lot of money for targeting, advertising, and whatever. Okay, so the shopping malls would love to have that. I would be very suspicious of incentives, which that will result in the shopping malls having more data about us. So maybe it's less with the government, but more with the private corporations. I'm not happy with such trade-offs between, it's just changing who violates our privacy. Is it the government or is it private corporations? Solidarity, responsibility, I think I've answered that. My sentiments do not lie with the Republican Party. And, we see how the United States has been handling this pandemic. Not so good, I would say, in capital letters and 4 exclamation marks as a tribute to the former president.
Thanks, Michael. Our time is getting shorter and shorter, so please try to keep your questions and answers short. Shmuel, are you with us?
I believe he said he has to leave.
Okay, so let's move to Tamar, please.
Hi, so thanks. This was very interesting discussion included. I wanted to sort of jump in to the discussion between Michael and Amnon and to suggest maybe an argument both of you have heard before, but I think gives an answer to this difficulty of squaring together the questions of privacy and the questions of solidarity and trust and responsibility and agency and the rule of law. And I think one of the reasons privacy needs this small but very dedicated army to fight its fights is because it's not something that the broader public sort of takes up and goes out to the street to fight for. It's not sexy enough in a way, I think. And that's why I've suggested in my scholarship that we need to be talking about freedom, about the right to liberty that's being harmed in all this surveillance, especially by the GSS surveillance relating to the corona crisis. And I think the privacy freedom fighters are basically doing the work of defending our freedom, but using, I think, a title that's not helpful enough in getting broad public support for their fight.
Thank you, Tamar. So I will respond briefly. I absolutely agree with the first part, at least, and maybe less so with the second part. And my concern with your first comment is, yes, people do not march on the streets to shout, "We want privacy," but which is a shame, maybe. But we are yet to see such demonstrations. However, people do react. Those that do understand more or less what's going on, etc., they resist. And resistance can be explicit demonstrations, but it can also be subtle. Miki Zar has written fabulously about resistance in the privacy context, resistance to surveillance. For example, many people, when they go out of their homes, they just leave the phone at home. Okay, so they leave the phone at home, and it's a subtle way to resist the surveillance. Now, they lose, because if they are exposed to someone who is COVID positive, etc., they might be infected without knowing, and this is unhelpful to them. If they are infected, they might infect others, etc. So it might be counterproductive. Privacy is part of liberty, but I would argue more in the European continental spirit that privacy is a matter of human dignity. And hence it operates not only vis-a-vis the government and the state, but, vis-a-vis the entire world. Our privacy matters not only when the government tries and does violate it, but also when it's a corporation, the shopping mall, the employer, the insurance company, etc. And I think Israeli jurisprudence has opted for the human dignity anchor / relationship of privacy more than to the liberty issue. In the current situation, they converge. It's we should protect privacy both as liberty and as human dignity. Both aspects are violated, and both should be preserved, I would argue. Thank you.
Thanks. Or
it's a bit hard to unmute. So actually, I just wanted to comment on Michael's. First of all, wonderful. I really enjoyed it, even though I heard parts of snippets here and there. But you mentioned that this is like a battle of few for many. And I think most human rights battles start this way. If we think about women voting rights at the beginning, you have a bunch of, back then, lunatics. Can you hear me?
Yeah.
Yes, we can. Okay, because it seemed like Michael can't. And the same goes, again, if you go back to the battle against the fight against slavery. At the beginning, it was a bunch of religious lunatics and a few people who had what today we would say a better understanding of where we're heading. So I would actually mention it's just that the others haven't picked up yet that we need to go after privacy as well. And if I would be happy to hear Michael's
Sure.
response.
Sure. With slavery, people realize that they are slaves. With privacy, it's often the case that people do not realize that they are under surveillance. In fact, what we have learned, as you know, with this entire Shin Bet surveillance, is that the Shin Bet has this technology since 2002. Okay? Long before anybody thought about COVID-19, of course, right? And what are they using it for? Well, they say they use it for national security. But our privacy in Israel has been repeatedly violated and breached, maybe for a good purpose. Maybe it's constitutional if it were to be challenged. It has not, to the best of my knowledge, unless there were secret proceedings, which I doubt it. Our privacy has been violated. Now, did we suffer loss of privacy? Well, we did not know. But of course, as with many other rights, the fact that I do not know that my right has been violated does not mean that it has not been violated. Okay? Even a person in COVID.
Michael, we lost you. Michael.
Exist and should be protected regardless of whether the person knows about the violation of the right. When we know about it, it may add to our frustration and other things and may lead to action. In this sense, we are not in a very good situation with privacy, not here and in other countries as well, although, once again, Israel is the only democratic country that we know of that has been using a national security tool against, I would say, rather than for, against its own citizens. All of this, as Gadi has mentioned earlier, applies to sovereign Israel, because what Israel has been doing for more than 50 years now in the occupied territories is way worse than anything that we have discussed in this discussion today, in terms of privacy at least.
Thank you. I think if there are no more comments or questions, I'll take the liberty to ask the last one. Michael, I share with you most of the components of your analysis, the importance of trust, the importance of institutions, the fact that we thought about all this crisis, or our government thought about this crisis in a military paradigm. Rachel, the obvious institution to handle the crisis was not involved, but Malal, Bitachon Leumi. But I want to focus on this issue of the security service, the GSS empowerment, and maybe plays the devil advocate. It's really a question of an egg and a chicken. Had we had trust in our institutions, handing over to the Shin Bet as opposed to private enterprises would not maybe be such a bad thing, because if we are trusting our institutions, our government, and maybe if we trust the institutions much more than we trust private entities, especially if you talk about these Google, Apple, global entities, then, maybe the option to have the General Security Service is actually better. And you say correctly that the usage of the technology exists for 20 years. They use it for other purposes. We don't know exactly what kind of purposes. They know contact issues. So if they already have it, and, had we trust them, and there would be some kind of check and balances or supervision, parliamentary supervision on their action, maybe, this would be the least worst option. Because technology, as you say, has to be employed. The investigations are not sufficient. People don't remember so and so. Second point related to that, the question of enforcing people to use the technology, or to use their phone, or to use the HaMagen is not a binary thing. Amnon talk about carrots, but it can be also some kind of nudging. That in order to get into an old people's home, which is a very vulnerable place, you have to come in with your open application. Or if you want to get into a very crowded shopping mall and it's not connected to the profits of the shopping mall, you don't hear me.
Yeah, no, I can. I was looking for I was looking for Thaler's book.
Okay, so if you want to go to a crowded place or a shopping mall, then you have to carry out. I think in some countries in South Asia, like South Korea, this is the rule, that you don't have to carry your phone all the time, but to certain places you have to carry your phone and you have to open the application. So there are various solutions between the enforcement and the total freedom whether to carry or not.
Okay, so I will begin with the first question. I think indeed it's a question of chicken and egg, as you said, and the important point was at the beginning. And the Israeli government has done two opposite things at the same time. On the one hand, it announced the Shabak surveillance, and on the other hand, it developed the HaMagen. And at the beginning, there were 1.5 million people, more or less, that have downloaded the HaMagen. I endorsed it, and some other people have publicly endorsed it, and I encouraged personally people to download and install the application, because I thought that this could be a vote in favor, a public vote in favor of civil as opposed, it's a governmental, but civil as opposed to a military or security-based solution. I think people, and 1.5 million people out of approximately, nobody really knows, 4.5 million people who have smartphones, so about a third of the relevant population have installed the application. It's not bad, okay? So technologically, it may not be good enough. The numbers should have been higher, but it was a vote of, I see that as a vote in favor of a civil application rather than governmental surveillance. Now, as the governmental surveillance continued, And clearly the government, the Ministry of Health deployed HaMagen, the application, but the government clearly did not support it. I would have loved to see our Prime Minister, which has, his powers of persuasion. I would have loved to see him go on TV, as he has done at the beginning of the pandemic on 8 p.m. and say, citizens of Israel, download HaMagen. Okay? He has not done so. He and the government have opted for surveillance rather than the other option. Now, I think that from a privacy point of view, and I'm not objective here, HaMagen in the first version was fantastic, okay? In the way it was designed. Who has control over the data? Which data is collected? Which data is transferred? In which direction? The direction is important. And the open source. I cannot underestimate the importance of publishing the code as open source, enabling people like Or and others to scrutinize what was going on there and to see that the government is not lying. This is how you build trust. However, the government has chosen otherwise, and public trust is difficult to earn and easy to lose. It has lost it. And as you or some of the other speakers have mentioned earlier, this is only one element of the entire relationship between the citizens and the government, which has completely sort of changed over the past year because of lots of other measures, right? Why are we undergoing a lockdown where in fact maybe it should be only in some places, but not in my place, and many, many other issues here. Nudge. Nudge could be fantastic, but the government didn't even get there. I would, if it could be a nudge, some carrot, some stick, but minor ones, or just a reminder, signs in shops. If you have the application downloaded, green light, but nevertheless still enabling those without a smartphone to enter, or those without the application, etc. So, nudge, okay. The government didn't even think about it. And that's regretful.
Right. This is very regretful, and it's regretful that we ended our time. Michael, thank you very much for a great talk and excellent discussion.
And thank you guys. Thank you, Eli, Michal, and the participants for your excellent questions and comments. Much appreciated. Thank you.
And thanks, Ido, for technically administrating us. We'll see you